and welcome to the inaugural Chief Justice Mark S. Cady Day event. We have a panel discussion today entitled Your Vote, Your Voice, Your Democracy, a voting rights event in honor of Chief Justice Mark Cady. I'm Jerry Schnurr. I'm an attorney in Fort Dodge, Iowa. I'm also the president of the Iowa State Bar Association, and it's my pleasure to be here with this panel as we discuss voting rights in the United States. But a moment to remember Chief Justice Cady. The Cady Day of Service is dedicated to the late Iowa Supreme Court Chief Justice Mark Cady. He was a judge for 15 years when he was appointed to the Iowa Supreme Court in 2011 or 1998, I'm sorry. In 2011, he became the Chief Justice of the Iowa Supreme Court and served in that capacity until his sudden passing on November 15th, 2019. Chief Justice Cady earned both his undergraduate and his law degrees at Drake University. Drake University Law School and the Iowa State Bar Association have gotten together to sponsor the Cady Day of Service event in honor and memory of Chief Justice Mark Cady's life, his commitment to public service, access to justice, and civil rights. So with that, I'm going to get into the introductions of the members of our panel. Emily Chaffa is active in several national, state, and local bar associations, including the Iowa Organization of Women Attorneys, Polk County Bar Association, National Association of Women Judges, Blackstone Inn of Court, and the ABA Judicial Division, National Conference of Administrative Law Judiciary. Ms. Chaffa received the Iowa Supreme Court Voice for Justice Award. To date, there have been 7 attorneys in Iowa who have received this award for their support and contributions to the administration of justice. Chaffa serves as the ISBA Diversity and Inclusiveness Committee Chair. She enjoys learning and telling stories of Iowa women trailblazers and other relatively unknown history makers. Henry Hamilton III is a federal administrative law judge. He has also served as a senior trial attorney with the U.S. Equal Employment Opportunity Commission, magistrate judge for the state of Iowa, a city prosecutor for the city of Des Moines, Iowa, and is a private practitioner and was a private practitioner with the parish law firm in Des Moines, Iowa. He is also the vice president of the Iowa State Bar Association. Hamilton is a voting rights enthusiast. He served as an international election observer and is a longtime member of the Election Protection Coordinating Committee. Mr. Hamilton is a 1988 graduate of Drake University in Des Moines and a 1992 graduate of Drake University Law School. Derek Muller graduated with a Juris Doctorate from the University of Notre Dame Law School in 2007. Upon graduation, Derek worked as a judicial clerk for the Honorable Raymond W. Gruender of the United States Court of Appeals for the Eighth Circuit in St. Louis, Missouri. He then became an associate practicing litigation with Kirkland & Ellis LLP in Chicago, Illinois from 2008 to 2010 before beginning a career in academia. Derek has been a visiting professor at Penn State Law, the University of Iowa College of Law, and the University of Notre Dame Law School. In 2011, he became an associate professor at Pepperdine Law School and was granted tenure in 2017. Mr. Mueller has taught courses in election law, federal courts, civil procedure, administrative law, and evidence. And he began teaching at the University of Iowa College of Law in the fall of 2020. Our moderator today is Ashley Frazier. Ms. Frazier is an attorney in Des Moines. She graduated from Drake Law School and Drake College of Business and Public Administration. She earned her Juris Doctorate and Masters of Public Administration degrees at Drake. She practices currently as an attorney in the Des Moines area, with the Iowa Coalition Against Sexual Assault. She's also an adjunct professor in the Paralegal Studies program at Des Moines Area Community College. There is a disclaimer that I have to give. Each panelist is appearing solely in their personal capacity. The views and opinions expressed do not represent the views of any of their past, present, or future employers. The information presented is current as of the date of this presentation, October 23rd, 2020. It is for informational and educational purposes only and is not legal advice. We will save time for questions and answers at the close of the program. But if you would like to submit a question, please post it in the chat area at any time during the program. And with that, I will turn the program over to Professor Muller.
Thank you so much. It's a privilege to be here to present to you to speak about voting rights with this distinguished panel. And what I'm going to do is I'm going to provide a little bit of a framing of how the Constitution was set up to think about voting rights as originally conceived, and then we'll get into some of the more contemporary applications and constitutional amendments moving forward. So when we think about the Constitution, maybe we focus a lot on the Bill of Rights. We think about free speech, the right to bear arms, freedom of religion, those kinds of things. And the original Constitution anticipates a lot of sort of focus on this structure of government and how individuals are elected to that government. And if you look at what's happening in 1787 in Philadelphia, it's a lot of fights about how we're going to create a government, how we're going to create this democracy that's going to be responsive to the will of the people, and yet at the same time sort of be insulated from excessive political pressure to sort of oppress minority factions within the United States or diffuse interest groups within the United States. And so we can think about the structure of government where Congress is created with a House of Representatives based on the population of each state, the Senate, which is based upon sort of statehood, and each state gets 2 senators, and the president, which is elected out of the Electoral College based upon each state's representation in the Senate and House of Representatives, and the judiciary, which is appointed by the president and confirmed by the Senate. So we have all these sort of government actors together, but at the core, and one of those sort of big debates that's happening early on is who gets to choose these individuals? And more specifically, who is eligible to vote? Who has the right to vote for these folks in these offices? And really, the Constitution doesn't provide, in its original form, a whole lot of guarantees about voting rights to individuals. When it comes to the House of Representatives, for instance, the Constitution says that the people of the states get to vote for members of the House of Representatives, but really only those who are eligible to vote in the state for the most populous state legislative chamber. So if you're eligible to vote in your state House election, you are eligible to vote in the federal congressional election. And so there's no express right to vote provided there, except to say, if you get it in the state, you get it in the federal government. And the states really control the levers there to decide who was eligible to vote, who was eligible to participate in this democracy. When it comes to the Senate, or as originally conceived, the Senate was not elected by the people, but the senators were chosen by state legislatures. The thought being these are supposed to be representations of the states, which is why each state gets 2 of them. And so the people don't vote for them, the state legislatures do, although the people vote for the state legislature. So it's a little bit indirect. And when it came to presidential elections, there were lots of fights about, do we think the people of the United States are capable of figuring out who the best person in the country should be to become the next president of the United States? It's a big country from New Hampshire to Georgia at the time. There were doubts about whether or not we should have too much direct democracy in the United States. And so the Electoral College was put in place to say, state legislatures, if you want to pick presidential electors, you can do that. If you want to leave it to the people to choose presidential electors, you can do that too. And so at the founding, we have actually not a whole lot in terms of guarantees for election of federal officials, really guaranteed only in the House. And it's incumbent upon the states to define who's eligible to vote and who's eligible to participate in these elections. And at the time, the state laws, they varied from state to state, but for the most part, they were focused on adult white men who were property owners. And in 21st century terms, we look back and we say that's a pretty limited set of people. But in the 18th century, it was a really expansive set of people, in the sense that democracy had not exactly been sort of a widespread popular concept. There were deep doubts about whether or not it would work. It worked in maybe some Greek city-states 2,500 years ago, some Swiss cantons, maybe the House of Commons in England, but there was skepticism about whether or not this system was going to work. And so at the time, it was sort of a limited pool of people who could participate, broad by contemporary standards at the time, narrow from our perspective today. And as we begin to move through sort of this American experiment after the founding, we see sort of some movement and progress toward broader and broader enfranchisement. Property ownership requirements begin to get reduced in many states. They're swapped out with a poll tax, which there's a second wave of a poll tax that Henry might talk about that's more pernicious. But the first versions of the poll tax were, listen, if you don't have an acre of property, maybe if you can pay $1, that's actually a less onerous requirement for a lot of individuals. And states began to reduce their property holding requirements in general. And then states began to look at, well, maybe people could elect the governor too, because sometimes the state legislature would elect the governor. And more states began to give the power to choose presidential electors to the people. And states began experimenting with electing judges or judicial retention elections. This isn't to say that it always sort of moved in one direction, but it is a suggestion that at the founding, while it was conceived relatively narrowly, over an extended period of time, it began to move toward broader and broader theories of enfranchisement. But this, of course, brings us to a major question in the United States, right? Where the original sin of the founding, if you will, slavery, was still a persistent problem in the South, and sort of racial divisions within the United States were an extensive problem into the Civil War. And so with that, I'm going to turn it over to Henry to talk about sort of the next, sort of the second founding, the era after the Civil War and Reconstruction.
Thanks, Professor. This year marks the 150th anniversary of the 15th Amendment to the United States Constitution. The 15th Amendment was the last of 3 Reconstruction amendments. Following the Civil War, there was the 13th Amendment, which outlawed slavery. Then the 14th Amendment provided birthright citizenship and equal protection of the laws to all citizens, including people who were formerly enslaved. Prior to the 15th Amendment, the right to vote, as Professor said, was largely restricted to white males over the age of 21. The 15th Amendment not only granted African American males the right to vote, but it was one of the initial steps in this long journey towards universal suffrage in the United States. And today, for my presentation, I'm going to discuss 5 things that you should know about the 15th Amendment. The first thing is that Iowa played an important role in the passage of the 15th Amendment. On February 3rd, 1870, Iowa made history when the state legislature approved the 15th Amendment and ensured its ratification. The amendment required approval of 3/4 of the states. At the time, that meant 28 of the then 37 states. Iowa provided the 28th vote. Now, Iowa's support of the 15th Amendment was not too much of a surprise to anyone following this issue. It was just 2 years earlier in 1868, when at the urging of Alexander Clark, a famous Iowa civil rights activist, Iowans went to the polls and voted to remove the word white from the Iowa Constitution as it dealt with who was qualified within the state of Iowa. The Iowa State Constitution, like so many constitutions of its time, restricted the right to vote to white males of 21 and many who had their own property. Well, after 1868, Iowa removed that, so African Americans had the right to vote in Iowa. So 2 years later, of course, it made sense that Iowa would vote for ratification of the 15th Amendment. And I'm going to attempt to share my screen here. Even after the passage of these amendments, however, there was still work to be done to ensure that African Americans had full participation in American democracy. As Frederick Douglass eloquently observed, slavery is not abolished until the Black man had the ballot. While the legislatures in the South retained the right to pass laws discriminating between Black and white, slavery still lives there. So Frederick Douglass, Alexander Clark, Sojourner Truth are going around the country encouraging Congress to pass legislation giving African American males the right to vote. Congress debated several versions of the 15th Amendment. Some of the more progressive versions sought to not only extend the right to vote to African American males, but also sought to prohibit voting qualifications based upon education and wealth. Proponents of these more progressive versions feared that states would use education and wealth requirements as proxies to disenfranchise the new African American voters. In the end, a more moderate version of the 15th Amendment was passed, and you should see that on the screen. The 15th Amendment extended the right to vote to millions of African American men who otherwise may have been prohibited from voting because of the color of their skin. While important to recognize what the 15th Amendment did, it's also important to recognize what the 15th Amendment did not accomplish. The 15th Amendment did not provide a universal right to vote. In fact, as a professor indicated in his opening remarks, Americans still do not enjoy a constitutional right to vote. The 15th Amendment only provided that to the extent the federal government or in states provided the right to vote could not be restricted because of race. As Emily Gould Schaefer will tell you later, the 15th Amendment did not guarantee women the right to vote. Women were not extended the right to vote until passage of the 19th Amendment in 1920. And on that point, African American women would not effectively enjoy the right to vote until passage of the Voting Rights Act of 1965. The 15th Amendment did not grant 18-year-olds the right to vote. 18-year-olds would not enjoy the right to vote until passage of the 26th Amendment in 1971. Importantly, though, the 15th Amendment did not prohibit states from restricting the right to vote because of education, wealth, property, or other so-called facially neutral qualifications. As feared, some states exploited these omissions to disenfranchise African American voters. The third thing I want to mention is that the 15th Amendment had immediate impact, but its success was short-lived, and for many decades thereafter, it was largely ineffective in securing the rights of African American voters. Congress quickly passed laws so the federal government could ensure the constitutional guarantees of the 15th Amendment by criminalizing efforts to suppress the African American vote, sometimes through violence. These laws increased African American participation in the voting process. Prior to the 15th Amendment, there were no federally elected African American officials and only a handful of state and local officials. African Americans began serving in the US Senate and the US House in 1870. From 1870 to 1900, 22 African Americans had enjoyed serving in the US Congress, and another 700 African Americans served in state legislatures. But like I said, the success was short-lived. The 15th Amendment fell victim to US Supreme Court action and exploitation of its internal weaknesses. In a series of rulings, the Supreme Court held that the 15th Amendment did not grant Congress the power to curtail the efforts of private citizens to restrict the right of African Americans to vote. And so what did this mean? Well, it largely meant that Congress had little authority to prevent private actors, the Ku Klux Klan, white supremacists, and related militias from interfering with African American voters. Emboldened by these rulings, these groups engaged with impunity in wholesale domestic terrorism against African American voters and their white allies. From 1887 through 1968, 3,446 African Americans were lynched. For African Americans in large parts of the nation, voting or even attempting to vote was fraught with significant risks, including death. The Supreme Court also held that facially neutral restrictions on the right to vote were legal, even though these restrictions disproportionately impacted African American voters. States took advantage of these rulings to exploit the weaknesses of the 15th Amendment. States utilized poll taxes, education requirements, literacy tests, grandfather clauses, understanding clauses, and similar efforts to restrict the African American vote. Poll taxes posed a significant economic barrier for African Americans, since until then, large portions of African Americans had not been able to earn wages for their labor and did not have significant opportunities to accumulate wealth. The 24th Amendment was ratified in 1964 to eliminate poll taxes. The educational requirements and literacy tests disproportionately disenfranchised African Americans. Until 1867, several states had anti-literacy laws, specifically prohibiting the teaching and reading to enslaved persons. And even in states where education of African Americans was legal, African Americans were segregated, provided inferior facilities, supplied outdated learning materials, if any materials at all, and otherwise subjected to unequal educational opportunities. Also, the tests were not equally administered. The election registrars had full discretion to determine who did or did not meet these facially neutral qualifications, and oftentimes their decisions were not appealable. And on the screen here, this is taken from Mississippi literacy tests or understanding tests. And you see there in section 18, the voter is required to explain a section of the Mississippi Constitution. Quite frankly, the voter would not be given the section until he or she sought to register. And so that's Mississippi. and Alabama, I pulled this. Like, for instance, a white applicant might be asked to explain this passage, whereas an African American voter might be asked to explain this passage. Well, the combined efforts of the Supreme Court rulings, the domestic terrorism perpetuated by the white militias, and the employment of discriminatory texts and poll taxes drastically suppressed the African American vote by making it illegal, life-threatening, or otherwise more difficult for African Americans to vote. African American vote in the South plummeted. In Louisiana, more than 130,000 African Americans were registered to vote in 1896. 18 years later, by 1904, the number of registered voters dropped 1,300 to 1,342. In Alabama, in 1900, more than 180,000 African Americans were registered to vote. Just a few years later, in 1903, the number had decreased to 3,000. By 1940, only 3% of eligible African Americans were registered to vote in the South. The lower numbers of voters have predictable consequences. For instance, from 1881 through 1967, no African Americans served in the US Senate. My fourth point I want to make is that perhaps the greatest legacy of the 15th Amendment is that it did give Congress the authority to enact the Voting Rights Act of 1965. Congress enacted the Voting Rights Act of 1965 pursuant to the authority granted in the 15th Amendment. This act is arguably the most effective civil rights law ever passed. It outlawed discriminatory tests, reinforced prohibitions against race discrimination in voting, and most importantly, set up a pre-clearance process to combat discriminatory states that were still engaging in discriminatory actions. For instance, a state or municipality would employ a discriminatory election scheme. The federal government would come in, successfully sue the state or municipality. The court decision, however, would take time. The court decision, even if it's favorable, wouldn't come down until 2 or 3 elections later. So this discriminatory elections scheme would have altered the outcome in 2 or 3 elections before there was a result. And then furthermore, after the successful litigation, states would just tweak their old policies by a little bit and then enact it in the next election. And so this whole cat and mouse game would pursue for another 2 or 3 elections. The Voting Rights Act declared enough is enough. The act required covered jurisdictions, largely states and subdivisions that had engaged in racially discriminatory practices, to submit their proposed voting changes to the United States Department of Justice or the Federal District Court in the District of Columbia before they could impose these new changes. This worked. Voting registrations in Mississippi increased from less than 10% of eligible African American voters to nearly 60%. In Alabama, the registered African American voters increased from 24% to 57%. By 1970, almost as many African Americans were registered to vote in Alabama, Mississippi, Georgia, Louisiana, North Carolina, and South Carolina than had been in the entire century prior to 1965. The last thing I'd like to say with my remaining time is that the 15th Amendment, the guarantees of the 15th Amendment are under attack once again. In 2013, the Supreme Court had a ruling in Shelby County versus Holder. For attorneys out there, that's at 570 U.S. 529, which essentially eliminated the pre-clearance process by striking down a section that the pre-clearance process is built upon. States wasted little time enacting measures carefully calculated to suppress the African American vote. Among other actions, states gerrymandered voters, enacted strict voting ID requirements, reduced early voting opportunities, purged voter rolls, and implemented pay-to-vote schemes. Things were so bad in North Carolina that the First Circuit Court of Appeals noted that North Carolina's new provisions, quote, targeted African Americans with almost surgical precisions. So a big thing going on now is that some states are maximizing opportunities to increase waiting times at polling locations in largely African American communities. A 2019 study by researchers from UCLA, Carnegie Mellon, and the University of Chicago found, quote, substantial and significant evidence of racial disparities in voter wait times. The same study cited evidence indicating that approximately 3% of voters will leave polling locations without voting when experiencing lengthy voting lines. In a close election, 3% can be determinative of the election. Lengthy voting lines also inflict wounds to our democracy, which do not readily heal. A 2018 Harvard study indicated that lengthy voting lines actually served not only to deter voting participation in that election, but also in subsequent elections. The study found that approximately 2 to 3% of voters experiencing long delays will cite those delays as reasons for not voting in the next election cycle. Reasons for the increased wait times in African American communities include concentrated use of dilapidated election machines, too few or poorly trained election workers, insufficient number of ballots requiring workers to locate and deliver more ballots to African American communities, burdensome absentee ballot requirements, too few ballot drop boxes, and closing of polling locations, resulting in an increasing number of voters going to a decreasing number of polling locations. The Leadership Conference on Civil and Human Rights reported that between 2014 and 2018, jurisdictions relieved from preclearance by the ruling in Shelby County versus Holder utilized 1,173 fewer polling locations despite evidence of overall increased voter turnout. So as I conclude my presentation, as we continue to celebrate the 150th anniversary of the 15th Amendment, the 100th anniversary of the 19th Amendment, and the 55th anniversary of the Voting Rights Act of 1965, we should look back in appreciation at how far we've progressed as a nation. At the same time, however, we must remain steadfast in our efforts to protect equal access to the ballot. We will not become that perfect union by accident. It will take work. And thank you. And with that, I'll hand off to Emily Gould-Chaffa, who will talk about the legacy of the 19th Amendment. Thank you.
Thank you, Henry. Good afternoon, all. I'm going to share a number of thoughts about the 19th Amendment, which we're celebrating 100 years, the past 100 years. This 19th Amendment generally gave women the right to vote. I use the word gave carefully. What you'll hear as I present the stories and some interesting information about many of the women who fought for the right to vote, this 19th Amendment wasn't just given, it was the result of many, many years, thousands of women, and a very strategic plan. But here are the actual words of the 19th Amendment to the United States Constitution, ratified by the Tennessee Legislature, the 36th and final state to do so on August 18th, 1920. It actually became part of the U.S. Constitution on August 26th, 1920. So as we celebrated this year, and August 26th is generally celebrated every year as Women's Equality Day. As you just heard Henry Hamilton state, the words of the 15th Amendment, the words of the 19th Amendment are similar. It says the rights of the citizens of the United States to vote shall not be denied or abridged or limited by the United States or by any state on account of sex, which means men, women have the right to vote. However, this didn't necessarily mean every woman immediately had the real access to cast a ballot, as you'll hear in a few minutes. Let me tell you first about Carrie Chapman Catt. She is most likely a household name in the state of Iowa. If she isn't, I'll tell you many interesting facts about her. Carrie Chapman Catt grew up in Iowa on a farm near Charles City. She became a feminist. She became a suffragist, she says, at age 13 when she learned that her very well-informed mother in a political home where debates, discussions of political candidates were part of the dinner table conversation, it came time to vote for President of the United States. Her family had been discussing the candidates at length. Cady was surprised when her mother wasn't dressed and ready to go vote with her father, her brother, and the hired men who worked on their farm. When Cady asked her mother why she wasn't going along to vote, she laughed, her father and brothers laughed and said, oh, women don't vote. So this launched Cady on what would be her mission for the rest of her life. Cady Lane, at that time, attended what was then known as Iowa State College, now, of course, Iowa State University. She was the only woman in her college class, graduated at the top of that class in 1880. She worked her way through college, as many of us, I'm sure, have. She decided to become a lawyer and did what many potential lawyers did in the late 1800s and into the early 1900s in Iowa. She worked in a law office and studied or read the law under the tutelage of a lawyer. However, this plan was abandoned when she received an offer to serve as principal of the high school in Mason City, Iowa, and then became superintendent of the Mason City schools at age 24, the first woman to do so, and at a very young age. Cady Lane met Leo Chapman, who owned a local newspaper and published that newspaper. She became an equal partner in that newspaper business, and she used that avenue to write about the importance of women's suffrage and the reasons why women needed the right to vote. Sadly, her first husband passed away shortly after their marriage, but she continued in that work. And what's important to say here is her first husband and then her second husband fully supported her work in the women's suffrage movement, which enabled her to have the impact that she did in this movement. Her second husband supported her by allowing her ample time and funds to travel around the country to advance women's suffrage state by state and nationwide. Cady Chapman Catt also organized some of the first local Iowa women's suffrage organizations and assisted with the first Iowa Women's Suffrage Convention in 1870. Her organizing skills came to the attention of Susan B. Anthony, who is probably more of a household name to many, if not all of you. Susan B. Anthony chose Cady Chapman Catt as her successor as president of the National American Women's Suffrage Association in 1900. Cady Chapman Catt was a great writer from her journalism background, an inspiring speaker, and a great organizer and strategic planner. She is largely credited with the winning plan, which ultimately led to the ratification of the 19th Amendment. Her winning plan included state by state and limited suffrage efforts from the thousands of women who were involved in this movement, as well as a parallel effort for national universal suffrage. I'm giving you all this information while I'm leaving on the screen some of the words of her speech on August 26, 1920. I hope that you're reading those and understand how important it is to vote, to honor Carrie Chapman Catt, the other women I'll speak about in a moment, and the thousands of women who worked for 72 years, if not longer, for the right to vote in the United States. So I hope you'll take these words to heart and follow her lead and do what she's asking you to do. Vote. Another woman who doesn't happen to be a native Iowan, but is a very important part of the women's suffrage movement, is Alice Paul. Alice Paul was part of the same National American Women's Suffrage Association as Carrie Chapman Catt. However, she did not agree with Carrie Chapman Catt's strategic plans. Alice Paul was more radical. She didn't want to wait any longer. She didn't want to try to get along with politicians who were not openly supporting the women's suffrage movement. So she founded the Women's Party. As I described some of the efforts Alice Paul made to advance the cause of women's suffrage, I want you to think about what she did more than 100 years ago and compare her actions to actions you've seen in the present day, especially this past summer, and what are now common ways to offer opinions in a public way and to try to persuade elected officials to take action. So for example, Alice Paul organized the first picket, which is basically a march or a protest with signs and banners in front of the White House. She did this during President Woodrow Wilson's second term in office. She had been trying in vain to persuade President Wilson to openly support the 19th Amendment and women's suffrage movement. She not only organized this first protest in front of the White House, she organized a group of women to stand outside the White House gates every day for an 18-month period, Monday through Saturday, to persuade President Wilson to support the ratification of the 19th Amendment. At that time, the president actually passed by those gates on foot with security detail, of course, but he actually had to walk past those women with their signs and banners every day for an 18-month period. Any of you who visited Washington, D.C., and especially near the White House, you may notice that there are protests of various types across the street from the White House in Lafayette Park almost every day. As has happened with recent protests, Alice Paul's and the members of her Women's Party met with some disagreement, is that maybe the nicest way to say it. In other words, they were arrested, placed in jail, tortured while they were in jail. Alice Paul went on a hunger strike, then she was force-fed, and all of this happened several times. So when Carrie Chapman Catt says on August 26, 1920, that many women have suffered for the right to vote, this is one of the things she's referring to, the courage of Alice Paul and other members of the Women's Party to be arrested, spend time in jail, be tortured for this goal of winning the right to vote. Another interesting parallel to what you see happening quite often in today's times, Alice Paul organized the first Women's March in Washington, D.C., down Pennsylvania Avenue, the day before President Wilson's second inauguration in 1916. This march included women from every state. Thousands of women marched in this parade. So even though Carrie Chapman Catt and Alice Paul had very different ways of advancing towards the same goal, they did have the same end goal in mind. And so Carrie Chapman Catt acknowledged Alice Paul's work in stating, "Women have suffered an agony of soul which you could never comprehend, that you and your daughters might inherit political freedom. That vote has been costly, prize it. In other words, vote." Another important women suffragist was Ida B. Wells. Ida B. Wells worked in parallel for Black women's right to vote. The life of Ida B. Wells was amazingly similar to Carrie Chapman Catt's path. Ida B. Wells was a journalist. She married a newspaper publisher and demanded and was an equal partner in that newspaper business in Memphis, Tennessee. So in 1910, while she was still living in Memphis, Tennessee, she wrote often about lynchings, as Henry Hamilton had mentioned that horrible time in our nation's history, and thought quite a bit about the connection between these lynchings, so many overt actions of discrimination, and connected them, and separate and inferior schools, and connected these injustices to the fact that African Americans were not allowed to vote. African American men, even though the 15th Amendment should have allowed them to vote, and of course women, neither Black or white women were allowed to vote in 1910. So I hope you take her words to heart, because they are as relevant now as they were back then. You can't protest against laws by choosing other lawmakers or retiring to private life, those who legislate against your interest, if you don't have the right to vote. Ida B. Wells eventually moved to Chicago, where she was very active in recruiting women in her neighborhood to vote, and eventually succeeded in organizing enough women to vote to elect the first Black alderman. And then she was eventually a candidate for public office in Chicago. One comment about the Women's March, I mentioned that Alice Paul organized. Sadly, that march was to be segregated. But Ida B. Wells, again, did not take no for an answer and marched in that Women's March with her state delegation, despite those requests. A couple more women I'll mention, and then we'll move quickly on to the rest of the program. Arabella Mansfield was the first woman lawyer in the United States. She was active in the women's suffrage movement and chaired that first Iowa convention. Her sister-in-law, Alice Bird Babb, was also a prolific women's suffrage speaker. And Alice Bird was one of the founders of PEO, an international women's organization. Annie Savory is, the last name Savory is probably a name to many of you if you visited the Savory Hotel in downtown Des Moines. Yes, that was owned by Annie Savory and her husband. Annie Savory was the first woman to speak publicly on women's suffrage in Des Moines, Iowa, and also spoke in Iowa City in 1868. She was one of the first women to attend and graduate from the University of Iowa Law School, and she was also admitted to the Iowa bar. She became a lawyer to understand the legal history of women's rights more fully, to support her work in the women's suffrage movement, not necessarily to work as a lawyer. And now one last person who is not a woman with Iowa roots or a woman active in the women's suffrage movement, but a very important person to demonstrate the fact that every vote counts. Remember, I mentioned at the beginning that the Tennessee legislature was the 36th and final state to ratify the 19th Amendment. This ratification passed by one vote. Harry Byrne, the youngest member of the Tennessee legislature, was torn. He personally supported women's right to vote, but believed his rural constituency did not support it. His mother, a college-educated woman, very active in the women's suffrage movement, wrote a letter to her son, and you can read the text here on the screen. He received that letter the morning of the vote on August 18th through the United States Postal Service, read it right away, thank goodness, and here's what it said. Vote for suffrage, be a good boy, help Mrs. Cat put the rat in ratification. Lots of love, Mama. So what are important lessons? That letter from his mother persuaded him to vote in favor of suffrage. One vote makes all the difference. And of course, as I tell the younger members of an audience like this, it's always important to listen to your mother. If you want to learn more, here are some books to read and some online resources. And with that, I will turn back over to Professor Muller to tell us what's happening now.
Well, thank you, Emily. We're running short on time. I'm going to give a little bit of an overview. Maybe there'll be time for a question or two at the end. But yeah, so we have sort of the original Constitution's framework doesn't provide these sort of guarantees. But as you heard from Henry and Emily, we have enacted a series of constitutional amendments guaranteeing some baselines. That is, once states give the right to vote, they cannot discriminate on the basis of race, color, previous condition of servitude, on the basis of sex. And later on in the 24th Amendment, not on the basis of a poll tax in federal elections, later extended to state elections. And then also in the 26th Amendment, ensuring that the right to vote is guaranteed to those who are 18 years of age and older. So over time, we've taken that constitutional document and amended it repeatedly to ensure that there are these sort of minimal baselines as we've moved toward broader and broader enfranchisement. Indeed, we entered the 17th Amendment, which allows for the direct election of senators. Just like you vote for members of the House, you vote for the Senate as well. All the states now hold popular elections for presidential elections. And so when we can think about different ways of conceptualizing this right to vote as sort of near universal enfranchisement. But that's not to say there aren't still some debates or discussions happening today about what sort of the remaining pools of potentially eligible voters might be. So, but this is a sort of a patchwork, right? It's the Constitution's baseline. It's federal laws, as Henry was talking about, with the Voting Rights Act, helping enforcing, giving teeth to the 15th Amendment. It's state laws that have made decisions and choices about how to define the electorate. And while states have sort of talked about, in some places, maybe non-citizens should vote, they do in some local elections. Should those under the age of 18 be eligible to vote? In some places, 17-year-olds can vote in primaries, or we pre-register voters at 16. Much of the debate happening today surrounds felons and ex-felons and felon disenfranchisement statutes. It's playing out in Iowa, as it played out in Florida, and it's played out around places around the country. But again, because the Constitution doesn't have this fixed definition, and in fact, the 14th Amendment expressly anticipates that states might disenfranchise felons and ex-felons if they so desired, states have moved toward broader enfranchisement laws consistent with the trend that we've been discussing. But there's still some debates that remain. So we can look at states like Maine and Vermont that allow incarcerated felons to vote. They're the only two states that do so, to other places like Iowa, Kentucky, Tennessee, Arizona, where it's much harder for any ex-felon to be eligible to vote, even after completing a term of imprisonment or a term of probation. And then there's debates playing out in Iowa, in Florida, and elsewhere about, well, what does it mean for a felon to have completed the term of punishment? We can think about prison sentences, but we can also think about fines and penalties. And on the one hand, we might say, if you are convicted of sexual assault and you've been incarcerated for a period of time and you owe payment to the Victims Restoration Fund in order to ensure that the victims of sexual assault are able to get the funding for counseling services that they need, it feels like something tied to your punishment. At the same time, we do have an amendment in the Constitution that says there's no poll taxes. And is it a condition of being eligible to vote to pay money? Is it something that's tied to the criminal side, or is it something tied to the voting side? And this is a debate that's playing out in the United States right now, too. So we are still having these discussions as a populace, right, about who is eligible to participate and how we define the electorate. And then finally, we are seeing a flurry of litigation this year pertaining to the coronavirus pandemic. And I want to emphasize one point. While there's a lot of things that are happening with the Supreme Court or the state Supreme Courts or district courts around the country, there's also a lot of decisions that are happening in state legislatures that have made amendments for greater accommodations in time of the coronavirus. There are executive decisions made by state secretaries of state, by county election officials and others to try to figure out what are the best rules we can have in place. And yes, there is the litigation piece as well. And all of this is sort of designed to say, we're coming up with the rules. The rules might need to change in the context. They've changed over 230 years, and we're going to keep changing them as we see fit. And that brings us up, I think, to the present day. But I appreciate the ability to participate and look forward to the next stage of the conversation.
All right. Thank you to that dynamic panel for giving us all of that information and for presenting so eloquently and well. We do have a few questions at the end. We're a little bit pressed for time, so I'm going to ask a couple of questions to our panelists. So number one, we are seeing news about cyber interference in this election. Can you tell us how Congress may provide more robust protection from cyber interference in elections?
I can jump. I've thought a little bit about this, and there was news this week, I don't know if folks saw, right, about Russian disinformation campaigns and Iranian disinformation campaigns. So one of the things that is happening right now when we think about cyber interference, for the most part, we've been fortunate that there haven't been hacks into election systems to alter or undermine the results of elections. And the Department of Homeland Security after 2016 has been working very closely with the states, secretaries of state in particular, to make sure that our systems are secure. The other side, however, is a really tricky one. When we think about disinformation or misinformation campaigns about foreign actors who conceal their identities, who try to divide us and sow discord on Facebook or social media. And so entities, the private actors, are doing the best they can to take down skeptical or disreputable content. I think the State Department is doing what it can to find out these things, but I think Congress keeps trying to send money to the states to update the problem, and perhaps one day we'll provide some more statutory guidance. But until then, we're sort of left with the best we can do.
All right, thank you, Professor Muller. I think this question would be good for Judge Hamilton. We got a question submitted from one of our attendees. Have there ever been African American voting registrars in the United States?
Well, sure. There's plenty. I actually served as a volunteer voting registrar in the city of Milwaukee. They're all over now. I think the more important question is, when did we begin seeing African Americans, and then did that stop? And I told you about the chronology of voting rights, and I don't know when the first African American register would have been in America. Perhaps the professor does, but with the end of the Civil War, the federal government sent troops to the former states of the Confederacy. And one of the things that they were able to do were to send registrars into those communities to register voters. So I know for sure by 1867, there would have been African American voting registrars throughout the South. and perhaps a handful up north. I don't have those figures, but don't forget the troops were pulled out of the South in about 1876 or 1877. And so I would imagine that it wasn't very safe for African American registrars at that point. Professor, am I?
No, I think you've got it right. I think even more important than whether there were registers, right? There were African American senators being elected out of the South right after the Civil War, right? So even more impressive, I think, in sort of the gains that were being made during Reconstruction, and then that all kind of goes away, right after about 1877 when Reconstruction ends, and certainly disappears by the era of Jim Crow in 1900.
All right, thank you for those answers. So our final question that we're going to ask today, because we're a little bit pressed for time, is what are things that we can do to improve our election process and ensure that every vote counts? And how and when can we take steps to do this?
I'll jump in and answer that question. First of all, we, especially Henry Hamilton and I, can give a number of voting rights presentations like this, and anyone can do this. You don't have to be a lawyer or a person obsessed with women's voting rights history like me to do that. You can help with voter registration drives. A number of voter registration drives have been taking place over the past several months. I'm personally participated in 2 voter registration drives for new citizens. Happened to be mostly from the Burmese community, but it was a wonderful experience to be able to register them to vote and then also explain the voting process to these new U.S. citizens. And then just volunteer here and there. Make sure we all communicate the fact that every vote really matters and that it is important to make a plan and take that time to vote in the way best for each person.
All right, thank you, Attorney Chapa. So to wrap this up, thank you so much for attending this voting rights panel, and thank you to our panelists for giving us such good insight into just the history of voting and just other things that revolve around voting. And if you haven't gotten anything from this, please vote, okay? That's really what the goal is in presenting all of this. So if you have not made a plan to vote, please make sure that you make a plan. The election is November 3rd, and you still have time. And mail-in ballots, the last day to request those is going to be on the 24th of this month.